welcome back. This is Class 20, our second topic within the larger discussion of corporate control transactions, aka M&A. And today we're going to talk about two special fiduciary issues that come up pretty routinely in change in control transactions. The first is controlling shareholder transactions, or as we describe it in the book, freeze-out mergers. So described because sometimes when a controlling shareholder owns a subsidiary, it decides to just merge the subsidiary into itself. What that usually means is forcing the minority shareholders of that subsidiary to take cash or some other consideration and just go away. So they're frozen out. And they're frozen out, we might say, they're sort of coerced to go away because they won't really have a whole lot of say in the deal. That is, the controlling shareholder owns a majority of the shares. It only takes a majority to cause a merger to go through, and so it will when the controlling shareholder wants it to happen. The other thing we're going to talk about is that sometimes when a person owns a controlling share, they sell it to somebody else. And that raises a small fiduciary issue. It doesn't really anymore. As we'll see in the case of Perlman versus Feldman, it used to. Nowadays, it kind of doesn't. All right, so to talk about freeze-out mergers, let's talk about the case of Weinberger versus UOP. So Weinberger, surely an important opinion. It says a lot of important things. It had significant consequences in Delaware, and for a while, it drove quite a lot of litigation. Freeze-out mergers were routinely challenged as loyalty violations following Weinberger. That's much less true now, and in particular because of a case we're going to talk about in a second called Kahn versus M&F Worldwide. That kind of litigation largely went away. All right, but anyway, so the facts of Weinberger are interesting. They're not complicated by any means. They're interesting because, there was sort of some shenanigans, and that's always interesting to see. And we'll work through them a little bit, but we're not going to dwell too much on the Weinberger case. So even though it's kind of long and there are a lot of facts to dig through, its real lessons are relatively straightforward. Okay, well, anyway, let's just take a look at the transaction a bit and the players within it, and then we'll talk about what the case says. All right, so sometime prior to this deal, Signal Corporation had already acquired just over 50% of the shares of another publicly traded company called UOP. Therefore, it was a controlling shareholder. And you'll notice here that even with a tiny majority of shares, oftentimes the parent corporation will just obviously be a controlling shareholder. And that's certainly the case here. That can be slightly more complicated if the board is elected with staggered terms or with cumulative voting or something like that. But generally speaking, having more than a majority makes you a controlling shareholder. Okay, well, at length, Signal decided that it preferred simply to cash out the minority shareholders of UOP and acquire their shares so that UOP would become its wholly owned subsidiary. Okay, so a pretty crucial fact in the case is that a number of individual people were officers and or directors of both of these companies. So Walkup, I love these guys' names, by the way. Walkup, Shumway, Arledge, Chitty, and Crawford are all officers and or directors of both companies. And in particular, Arledge and Chitty work for, their directors and senior management of Signal, and they also have board seats at UOP, and they use that position at UOP for the benefit of Signal, and that was a big issue. Also, Mr. Crawford had been an official of other Signal subsidiaries, and he was installed as the president of UOP, the CEO, at a time when UOP was going to negotiate for its own sale to Signal, and that was sort of a significant fact as well. All right, during the period of negotiations, it's significant that the officials of Signal did some internal analysis about the desirability of the acquisition. And in particular, Arledge and Chitty, who are both finance officials within Signal, were asked to do a quote-unquote feasibility study. This is very similar to the facts of Smith versus Van Gorkum. Insiders did a study about whether a deal could be pulled off as a matter of financial plausibility, but they didn't actually do any inquiry into an important question for their fiduciary obligations, which was to ask what is the actual value of the company and what should be paid to its shareholders if one wants to find a price that complies with one's fiduciary obligations. And so Arledge and Chitty prepared this report, which was, dare we say, kind of a Chitty job. A key fact discovered in this Chitty report was that Signal could have made money. It could have been a reasonable deal for Signal to buy UOP at any price up to $24. And that was a number that was never disclosed to anybody at UOP, or so the courts found. And that was kind of bad for Signal because ultimately Signal bought the company for less than $24. $20 to $21 was quite a profitable price for Signal, and that's what they got it for. Key to all of this is that Mr. Arledge and Mr. Chitty used their positions as directors of UOP to find information that was relevant to determining whether $24 was a viable price. Namely, they used confidential financial information to make judgments about what UOP's future profitability would be. So in other words, they used their positions as fiduciaries of UOP to get information that was useful to Signal, and they used it solely for Signal's benefit in a way that was adverse to the minority shareholders of UOP. Okay, so only a couple of things are really important to say about Weinberger beyond the facts. The court observed the obvious, which was that this is a duty of loyalty case because Signal Corporation is a controlling shareholder and therefore it owes fiduciary duties, and it acted under a conflict of interest in acquiring UOP. The plaintiffs challenged it on that basis. A question for the court, first of all, was whether the ordinary intrinsic fairness test should apply here, because after all, the deal was in fact submitted to the minority shareholders of Signal, as is required by statute. A vote of the shareholders was required before the deal could go through, and the shareholders approved it. And so a question was, well, does that constitute a ratification that should affect the standard of care? And the court said no, because the ratification was uninformed. The minority shareholders weren't informed of the fact that Arledge and Chitty had used UOP's confidential information to develop advice for Signal that was adverse to UOP and was never disclosed to UOP. So the minority shareholder vote as a ratification just had no effect. So it's an intrinsic fairness test in which Signal would still bear the burden of proving fairness. And as the court says, at that point, the case becomes kind of a garden variety duty of loyalty case. The court says, first of all, this was procedurally unfair because for several reasons, really. I mean, the discussion there is actually kind of interesting. The court says, look, first of all, this transaction was initiated by Signal. Signal initiated the thing, and for purposes of its own. That's fine. That's always how it is in a controlling shareholder acquisition. But it is a first fact that perhaps implicates the procedural fairness of the deal. Moreover, the consideration of the transaction was very rushed. It happened over only just a few days. Signal, UOP's outside investment banker, was given only a few days to review the fairness of the price, and indeed it appears that the banker didn't do much. They rushed through it really quickly. They did due diligence for a day and reviewed the terms of the deal very briefly. And the deal was negotiated in a very quick series of telephone conference call meetings without too much deliberation. But it gets so much worse, and that is where the Arledge and Chitty report comes in. It was adverse to UOP, developed with information taken from UOP in violation of fiduciary obligations and never disclosed to UOP. So on a procedural basis, the thing could never possibly have passed muster. The court says the matter of substantive fairness really goes to whether the price was adequate, and that's not necessarily a question that can be answered by the at the appellate level, and so we need to have further consideration of whether the price was appropriate, and that is for the Court of Chancery. Okay, so Weinberger is a relatively simple um, case in duty of loyalty terms, but it raises this question: what is a controlling shareholder supposed to do? Like, what exactly are you supposed to do to make sure you don't get in trouble? Do you have to pay the highest possible price for the subsidiary? Do you have to disclose your own highest, the highest price you'd be willing to pay, or what? The answers seem to be that no, you don't really have to do that, but you have to do something procedurally to make sure that the subsidiary is well represented. And as the court says several times, what was really lacking in the signal facts is that nobody was negotiating on behalf of UOP. That is, you had this sort of charade of a negotiation, but it was between one board and another board, both of whom really represented only the interests of Signal, and no one had the interests of UOP primarily at heart. And that's what has to happen. There has to be some sort of independent person or persons on behalf of the subsidiary to make the deal into something more like an arm's length transaction. Okay, so that left open some questions, though, which were, what exactly do you have to do, and what happens when you take certain steps? For example, if you have a fully informed ratification by the minority shareholders, what effect does that have? Well, Weinberger itself indicated that if it really was fully informed and uncoerced, that shareholder vote can be a ratification, but its effect is simply to shift the burden in a duty of loyalty case from the defendant to the plaintiff. And we saw that before when we talked about ratifications in the effect of shareholder and board ratifications in the Wheelabrator case. But there was still some uncertainty left open. And that brings us to our next case. That brings us to a case called Kahn versus M&F Worldwide Corp. On page 726 of the second edition. So this case, we don't get any of the facts and they don't matter. It's just a controlling shareholder transaction. A controlling shareholder caused its subsidiary to be merged into itself. What's important, it's an important case in a lot of ways. It answered some important questions, had a significant effect on Delaware fiduciary litigation. But what's important about it is the special set of sort of black letter rules that it set out. So Kahn really answers the questions that were left open in Weinberger. So Weinberger itself, again, had suggested that if the subsidiary appoints an independent board or board committee to negotiate on its behalf, and they do a good job, that could affect the standard that applies in later fiduciary litigation. Some cases followed that suggested that the effect of that would be to not to do away with duty of loyalty challenge. That is, the standard that applies would still be the intrinsic fairness test, but it would shift the burden to the plaintiff. Okay, so we had this nice rule suggesting that negotiation by an independent board committee of the subsidiary would shift the burden to the plaintiff. We know that already, because we've seen it before, and Weinberger itself confirms it, that if a controlling shareholder merger is approved by a disinterested majority of the minority shareholders, that also shifts the burden to the plaintiff in an intrinsic fairness case. Okay, well then Kahn comes along and just really takes away any doubt about what happens. And in particular, it says if you do both of those things, then the case becomes a business judgment rule case. Okay, and that is why in the book we thought we were quite amusing by adding this picture of a man wearing not just a suspenders and not just a belt, no, both belt and suspenders, the simultaneous deployment of procedural protections, and there you have it, friends. The thing about this case, though, before we get into it, let's do just a slight review. Remember what has to happen. In a Model Act jurisdiction, and it's true in Delaware as well, when a controlling shareholder acquires a subsidiary. Now, technically, that triggers shareholder voting rights for the for the shareholders of the subsidiary, just like in any other merger. The subsidiary will not be the surviving entity, and therefore under Section 11.04, in a Model Act jurisdiction, the subsidiary shareholders are entitled to vote. And that's true even though there's a controlling shareholder, meaning that it's a foregone conclusion that the deal will be approved. Okay, but remember, in Model Act jurisdictions under Section 11.05, and Delaware has a very similar rule, if the controlling shareholder has 90% or more of the shares, then you don't actually have to go through with that formality. Indeed, even the board of the subsidiary doesn't have to approve. The controlling shareholder can just cause it to happen. Okay, so you might wonder, in deals like Kahn and Weinberger, Weinberger was a case where it couldn't be a short form merger under 11.05 or Delaware 262 because the shareholder didn't have more than 90%. But in a lot of deals, they have minority ratification anyway, even though it's not legally required. Okay, well, the reason they do that, it's probably pretty obvious, but the reason they do it is because of what we're talking today. It has an effect on subsequent litigation, subsequent fiduciary litigation. If some dissenting shareholder challenges the deal as in violation of the controlling shareholder's duty of loyalty obligations, the standard that applies will vary depending on what procedures were followed, and ratification by the minority shareholders can at least flip the burden to the plaintiff to prove unfairness. Okay, and this is important to defendants because the intrinsic fairness standard in which the defendant bears the burden is really a pretty demanding standard, and it's very favorable to plaintiffs. Okay, well, anyway, so Kahn sets out a number of specific requirements that have to be followed and a number of detailed little rules. So I thought we'd write them down on a little chart, and here we go. Okay, so just to review, the rules are that where a controlling shareholder acquires a subsidiary, well, ordinarily that's a duty of loyalty case in which the defendant bears the burden of proving fairness. However, if the transaction is either negotiated by a truly independent board or approved by a fully informed majority of the minority, then the burden shifts to the plaintiff. The rule of Kahn versus M&F is that if the deal is conditioned on both, then the business judgment rule applies. Okay, but before Kahn can actually apply, it turns out that actually quite a number of things have to be true, according to the Kahn court. So first of all, and by the way, all 6 of these requirements appear in the very first paragraph of the opinion on page 726, and then they're elaborated at a little more length starting on page 728. So first of all, the deal has to be conditioned from the beginning. As the court says, ab initio, so in Latin that means from the beginning. It has to be conditioned on both protections. So if the controlling shareholder initiates the transaction, which is what always happens, the controlling shareholder has to make clear the transaction will not happen unless we have both an independent committee of the subsidiaries board and a disinterested approval by the minority shareholders. Okay, next, the special committee must be independent, which basically means that none of them work for the controlling shareholder. So you can't have people who are officers of the controlling shareholder or directors of the controlling shareholder serving on this special committee. Incidentally, as we've seen a number of times, independence does not mean that the director was not elected by the controlling shareholder. As a general matter, all the directors will be elected by a controlling shareholder. Next, the special committee has to be fully empowered, which means they can hire their own advisors. Presumably, they could hire a lawyer, an outside investment banker, or financial advisor, whatever. And most importantly, they have to be able to say no definitively. So the controlling shareholder can't make a deal go through unless the special committee says, okay. That would fail if the full board of the subsidiary retains the right to overrule the special committee. All right, in doing its work, the special committee has to comply with the business judgment rule. As usual, that's probably not very hard so long as they make themselves reasonably informed. They don't allow themselves to be coerced, and they do a reasonably competent job. It's very unlikely that this element could fail. All right, and then before the minority of the majority votes, they have to be fully informed, and they must be able to make their decision without any coercion by the controlling shareholder or anybody else. All right, and that's Kahn and M&F. And that also concludes the discussion of the freeze-out merger. So it's pretty simple. Controlling shareholder transactions always raise this issue potentially of duty of care litigation. After Kahn, though, that possibility is largely foreclosed. No controlling shareholder of a Delaware corporation would fail to do the two steps required by Con, because it basically means you've insured yourself against any possibility of liability, and so now they do that. Okay, well, there are some think about this questions following the Con case, and these are actually kind of review questions a little bit, but pretty useful review, I think. Okay, so these are the think about this questions that appear on page 732. Road Motors Incorporated, a Delaware corporation, entered into a transaction with another company called Megabeast Motors Corporation. Megabeast, a publicly traded Delaware corporation, issued 500,000 of its own shares as consideration for purchase of the bulk of Road Motors' assets, which were its manufacturing facilities, its inventory, its patent rights, and so on. Pursuant to the transaction, Road Motors retained $1 million to pay off whatever liabilities remained. Finally, also pursuant to the transaction, Road Motors Board issued an in-kind dividend to the company's shareholders consisting of all the shares of Megabeast stock received, and then recommended that they vote to dissolve Road Motors. The shareholders so voted, and Road Motors was dissolved. Okay, so this is just like the transactions we saw in the de facto merger cases. This is like the transaction in Ferris versus Glen Alden and the transaction in Heraton versus Arco Electronics. Question F. If they so chose, could Road Motors shareholders bring a legal action to challenge the company's acquisition, alleging that they should be entitled to voting or appraisal rights? Well, the answer is no, because notice that Road Motors is a Delaware corporation. Delaware does not recognize the de facto merger doctrine, and under Delaware law, since this was merely a sale of Road Motors' assets, even though they constituted all of its assets, there is no right to shareholder voting or appraisal. If this had been a jurisdiction that recognizes de facto merger doctrine, probably both voting and appraisal rights for the selling company's shareholders, that is Road Motors shareholders, would be provided. Question G. If they so chose, could Megabeast shareholders bring a legal action to challenge the company's acquisition, alleging that they should have been entitled to voting or appraisal rights? And again, the answer is almost certainly no. This is Delaware again. It wouldn't be treated as a de facto merger. The shareholders, therefore, it's just a purchase of assets from the perspective of Megabeast. Megabeast was the buyer of some assets, and shareholders never get to vote on that in any jurisdiction. And they don't get appraisal rights for it. That is, if your company in which you are a shareholder buys something, you don't get voting rights or appraisal. It's a minor question whether they could have gotten those rights if this was treated as a de facto merger, but that brings us then to question G. Question H, rather. So question H. Would it make a difference in either problem F or problem G if Road Motors and Megabeast were incorporated in a state following the Model Business Corporation Act? And the answer is it definitely would. So first of all, as to Road Motors, because this is a sale of substantially all of the assets of Road Motors in a Model Act jurisdiction by statute law, the shareholders of that company would enjoy both the right to vote on the deal and appraisal rights. Megabeast is a different story. Even in a Model Act jurisdiction, the shareholders of Megabeast would not be entitled to voting or appraisal as a matter of statute law because Megabeast is the buying company. When you're a shareholder in a corporation and your corporation buys something, you never get voting or appraisal rights for that just because the company went out and bought something. Okay, but in a Model Act jurisdiction that's not Delaware, the de facto merger doctrine might apply, and that could affect Megabeast. We've never said this before, but it's probably worth saying. Even in Model Act jurisdictions, when a transaction is set up like a de facto merger, the statute itself does not, in fact, cause all of the legal attributes of a merger to apply. And there are some that don't apply that are quite significant. So, for example, one of them is that the liabilities of the selling corporation do not transfer to the acquiring corporation. So imagine, for example, that Road Motors, which is a car maker, produced defective cars, caused injuries, and plaintiffs came to have products liability claims. Well, but let's assume, though, that the injuries occurred after this transaction. Well, that's pretty bad for those plaintiffs because they now have big claims against a firm that's been left with only $1 million to cover all of its liabilities, and those claims do not, as a matter of statute law, transfer to Megabeast. If the de facto merger doctrine applies, though, this would be treated like a merger with all the legal attributes of merger, and therefore they could sue Megabeast. The other thing that de facto merger doesn't, the other thing that the Model Act doesn't impose in sale of asset transactions is they don't give it doesn't give any rights at all to the shareholders of the acquiring corporation, any of the rights that might apply in the case of a true merger. So in a Model Act jurisdiction that recognizes the de facto merger doctrine, this case definitely could come out differently. And if this were treated as a de facto merger, then the shareholders of Megabeast could in fact have both voting rights and appraisal rights. But remember, first of all, on the facts here, probably the shareholders of Megabeast don't get voting rights because it looks like Megabeast is the so-called surviving company in this merger. Remember that under Section 11.04H of the Model Act, the shareholders in a merger don't get to vote if their company will survive intact unless certain specific things occur, like the merger requires an amendment to the Articles of Incorporation, or the company will be issuing more than 20% of its own stock as part of the merger, etc. So unless one of those things apply here, these shareholders won't get a right to vote. And then remember, too, that under Section 13.02, you're entitled to appraisal rights only if you would have been, in a merger, that is, only if you would have been entitled to vote on the merger. So if you're a shareholder in the surviving firm, you're not going to get appraisal rights unless, again, there was an Articles Amendment or an issuance of 20% of the stock or something like that. So probably these folks don't get voting or appraisal, even if this is treated as a de facto merger. Moreover, even if they did, remember that there's an exception from appraisal rights for companies that are publicly traded, and that's contained in Section 13.02B, and Megabeast is publicly traded. So probably the shareholders of Megabeast wouldn't get anything, even in a Model Act jurisdiction, even if it recognized the de facto merger doctrine. So that brings us to the second topic for today, second and final, which is fiduciary issues that can surround transactions in which a person or a company owns a controlling share of a corporation and sells it to someone else. Okay, so in terms of the legal rules that surround the transaction itself, just the formal rules governing the procedure by which that transaction happens, as a matter of corporation law, there aren't any. That is, the corporation statute doesn't really have anything to say about when a person who owns a controlling share wants to sell it to another person. It's really just a bilateral, one-to-one transaction, and it's a matter of contract, really. Okay, but a concern, at least at one time in American law, was should we be concerned about the rights of minority shareholders in those cases? And could there be fiduciary issues? Controlling shareholders, after all, are always fiduciaries, and if they sell their control, is there any concern about breach of fiduciary obligation? Okay, so there's a case in the book called Perlman versus Feldman on page 733. This is an old case of the Second Circuit, and it says that as far as that court is concerned, indeed there is a fiduciary problem. And in fact, that court found the defendants there to have breached their fiduciary duties. The concern for the court has everything to do with the so-called controlled premium. Remember, when a person buys a controlling stake in a corporation, typically they have to pay quite a lot more for it than they would pay on a share-by-share basis if they just bought one share or a minority share. And that's, it's described in various ways, but it's basically explained by the fact that having control of a corporation might be worth more than merely owning shares. If you have control, you can do what you want with the corporation. You can perhaps make it more profitable than its current owners are doing, or you could break it up and sell it. Sometimes the most valuable use of a company's assets are to sell them off, or at least that's what some people think. Okay, so you have to pay a controlled share. It so happened, though, that at least at one time, this is in 1955, after all, when this case was decided, that seemed a little bit fishy. It seemed almost as if the controlling shareholder was taking some sort of bribe or taking some sort of benefit that belonged in some way to the minority. Just jumping ahead to the conclusion, I want to say this is really no longer the law. It is no longer true that a court would say selling a controlling stake in a corporation at a control premium price in some way violates one's fiduciary duties or disadvantages the minority shareholders. So in other words, the law as it now exists is what the law as is stated in the dissent in this case by Judge Swan. Also, it is captured in a decision that appears after this case called Zeitlin versus Hansen Holdings Incorporated on page 739. That's another one of those opinions that's included here, not because the case itself is important, but just because it states what's the current majority view. Okay, so the rule, in short, from the dissent and from cases like Zeitlin, is that, yeah, sure, in fact, controlling shareholders can sell at whatever price they want. As far as we're concerned, the price to be negotiated in that sort of case is the market price, and the market price of a controlled share is always higher than the minority, or pretty much always. Both the dissent and Zeitlin recognize that there could be some circumstances in which a deal is so abusive or some bad conduct has occurred, and therefore that we should put constraints on the controlling shareholder, but those will be unusual circumstances. Okay, so let's think just briefly about the facts of Perlman versus Feldman. So we have a company here called Newport Steel Corporation, that was acquired by a consortium of buyers of steel. It's relevant that this happened during the Korean War, which was a time when steel was in short supply. That happens during wartime. Things tend to get more expensive. And it appears that because the price of steel was going through the roof, these buyers wanted to get their hands on a ready and reliable source of supply for their products. These buyers, which were described as the Willport Company, were shipbuilders, I believe, and they need a bunch of steel. Okay, well, Mr. Feldman was a controlling shareholder. An interesting little review question for us here is, remember, whether a person is a controlling shareholder or not is itself a question of fact, and so occasionally it can be kind of uncertain. And this is kind of a nice case showing us why. If you look at the footnote 6 on page 733 from the opinion, we're told that Mr. Feldman himself didn't actually own a majority stake in the company. And indeed, even when added to the trust over which he had control, he and his family members only hold about 33% of the stock. And yet he is held to be a controlling shareholder. And that's so because he also held significant positions of authority within the company. He was the CEO. He also was married to a person whose father had founded the company. It was a family business, and he's a member of the family. So the collection of facts suggests that he's controlling. An interesting fact that goes to control is that he only has 33%, but the rest of the company seems to be held by a relatively dispersed group of shareholders. And that's relevant because if there's nobody else in the company that has a big stake, it will be difficult for any of them to collect enough votes amongst themselves and actually coordinate their voting activities to really oppose the person who has 33%. So a person with 33% in a company where all the rest of the stock is dispersely held is probably going to be able to call the shots. Like, he's going to show up and have 33%. There may not be, there could be a quorum even if only, 17% of the remainder of the company shows up. So he may be in the majority at most stockholder meetings, right? Because a quorum is only a majority of those entitled to vote. All right, so he's probably a controller. You might wonder, does it really matter? Since he was also an officer of the corporation, he had fiduciary duties anyway. That is true, but it's still worth thinking about these things once in a while. All right, well, anyway, make a long story short, Feldman negotiates a sale of the company to this Willport Group. They pay a substantial control premium to him. In the background, the majority of the court seems to be particularly concerned that he may have been taking something of a bribe here. In other words, he wasn't just receiving a control premium; he was getting paid by these buyers. He was getting they sweetened the pot because they wanted him to help them take advantage of the company in some way. And you might ask, well, why? The suggestion seems to be that, well, what they really wanted was not so much to own this company. They wanted to own cheap steel. They wanted to get a cheap input for their products. And so maybe they would get a hold of this company at a time when it should be earning big, fat, massive profits for its own shareholders because steel is in short supply, it's at a high price. At such a time, the corporation should be taking advantage of high demand for the product, but these buyers perhaps would force it to provide them with steel at below market prices. Okay, well, it's at least plausible. And if that's what they were trying to do and they were paying off Feldman to help them do it, that seems like a fairly plausible theory of injury to the corporation. And that seems to be what persuaded the majority. And the majority said, in the end, yeah, if a controlling shareholder takes a control premium payout, that breaches their fiduciary duty. Okay, what's interesting is not the majority's holding because, again, it's not the law. The courts would no longer hold this. What's more interesting is to think about whether this really is a plausible theory. And ask yourself, what would happen if a controlling shareholder acquired a company, forced the company to provide it with below market products, but there are still minority shareholders? Well, they're going to sue. And the suit is going to be what? Is it going to be business judgment rule? No. It's going to be a duty of loyalty because that controlling shareholder owes fiduciary duties. It's forcing the corporation to sell stuff to it, and therefore it has a conflict of interest. And the intrinsic fairness test is going to apply. And the fundamental question in intrinsic fairness is whether the thing was substantively fair. In other words, was the corporation getting a fair market value for whatever the transaction was? And the answer would be no. So the theory had a superficial plausibility to it, but it probably didn't really carry water. And moreover, you kind of have to wonder, would that controlling shareholder really want this anyway? Because after all, they might be getting cheap steel, but what other asset would they be hurting? Like, there's another thing they happen to own now that they would be decreasing in value if they're causing this company to pump all its steel to them at below market prices. And that is, they now own stock in the company, and they would be reducing its value even after they had just paid a big premium for it. Now, who knows? It might work out to still make sense for them to do this, but there's reason to doubt it. Those are all reasons that explain why Judge Swan dissented in this case. And here's what's interesting about Judge Swan's view. He says that ordinarily he would find this to be perfectly fine, that control shareholder can sell their property just like anyone else can, and the price at which they sell should be set by negotiation. In other words, it should be set by the market. Judge Swan says that it's still possible that a transaction could violate the controlling shareholder's fiduciary duties if there's evidence of significant bad conduct. But he says that really is only going to be the case where there's evidence that the controlling shareholder deliberately engaged in some effort to sabotage the company as a part of the deal. So in other words, if it could really be shown that, yes, indeed, Feldman was bribed in order to help the Willport Group take advantage of Newport, force Newport to give away its steel at below market prices or whatever, then yes, that's a case. But there just wasn't evidence of that here. It seems that Feldman sold at a controlled premium price, and that's okay. Zeitlin actually captures this rule nicely. The Zeitlin versus Hansen Holdings Company case on page 739 nicely captures the rule. Generally speaking, a controlling shareholder can sell their shares at will at whatever price they can negotiate, the only limit being the following. This is from the second full paragraph of the opinion. I guess it's actually the third full paragraph of the opinion. The court says, it has long been settled law that absent looting of corporate assets, conversion of a corporate opportunity, fraud, or other bad acts of bad faith, a controlling stockholder is free to sell and a purchaser is free to buy that controlling interest at a premium price. Okay, and that's the rule, and that's all there is to it. All right, now the very last thing in today's reading assignment is think about this question. So let's take a look on page 740. Question I, is it clear that if applied to the facts of Perlman, the Zottlin approach would lead to a different result? And yeah, it would probably come out differently. It's hard to imagine that the facts of Perlman versus Feldman would arise to the level of looting of corporate assets, conversion to corporate opportunity frauds, or other acts of bad faith. Question J. Jerry owns 51% of the voting stock of Supposal. He is approached by Blaine, who's well known for acquiring corporations and causing them to liquidate in order to turn a quick profit. This has a bad tax consequence for minority shareholders. Supposal shares are currently selling at $25 on the open market. Blaine offers Jerry 27 per share. May Jerry accept? The answer is probably yes. Again, a bad tax consequence for the minority. Probably just does not rise to the level of looting of corporate assets, conversion of an opportunity, fraud, or other acts of bad faith. I mean, when you buy stock, you know that certain things can happen, including tax consequences. All right, and finally K. Carrie owns 51% of Assumpsit Incorporated, an up-and-coming manufacturer of sump pumps. She's approached by Pump It Up, a competitor, offered $15 a share, even though prevailing price is $10. She does not know, but strongly suggests that Pump It Up will either operate Assumpsit in a manner advantageous to itself or merge with it at a time not very desirable to the minority. May she accept the offer? You know, this is closer, but probably still it's kind of like Zottlin. It's more like the Perlman case in that there was some plausibility to the theory that somebody was paying off Feldman to help them abuse the company. But again, it probably has to rise to the level of evidence of pretty serious, deliberate, nefarious bad conduct, and that doesn't really sound like it here. And finally, Larry owns 51% of Surmise Corp, a software company. He can and does elect all 7 members of the board. He's approached by Mary, who would like to serve on the board in order to earn director's fees and to enhance her resume. She offers to pay him a quarter of the fees she earns for each year that he elects her. May Larry elect Mary and take the payment? Okay, so this is pretty different. Mary's not trying to buy his stock. She's trying to pay him to vote for her, and that probably is going to be seen as a pretty different case. You might wonder if they're similar, since it's sort of like the allegations that seem to have underlied the Perlman case, like somebody's being paid to help, somebody's being bribed to abuse the company, whatever. In acquisition transactions, that's just not how we look at it, though. There has to be evidence of really, really bad wrongdoing, whereas in this case, Mary's actually paying somebody to elect her to the board to do perhaps bad things, and that is like cases we've seen before where contracts of this nature, contracts that would undermine the independence of the board of directors, are simply void as against public policy. And this deal here probably would be void against public policy, and it also presumably would violate Larry's duty of loyalty.